Ekscelence, dame i gospodje, dragi prijatelji, dobrodošli u imenu Mednarodnog inštituta za bližnjovzhodne i balkanske študije IFIMES. U posebno čast nam je da je danas z nami predsednik sveta našega inštituta, profesor dr. Robert Donia. Dr. Donia je raziskovalec na Centru za ruske in vzhodnoevropske študije in profesor na Univerzi v Michiganu ter gostujoči profesor na Univerzi Kalifornija v San Diegu. Je avtor številnih knjig, člankov in recenzij v znanstvenih revijah, ki se ukvarjajo z nekdanjo Jugoslavijo, med drugim pa je tudi svetovalec Mednarodnega sodišča za vojne zločine v Hagu. Pred nekaj meseci je postal tudi dopisni član Akademije znanosti in umetnosti Bosne in Hercegovine in v pripravi je prevod knjige profesora Donije Tradicija, ki so je izneverili v bosanskem oziroma srbohrvaškem prevodu. Danes bomo poslušali njegovo predavanje z naslovom Je pravica pomembna? Zgodovinska nujnost ocene ICT-a. Predavanje bo potekalo v angleškem jeziku, po predavanju bo sledil pogovor s profesorom dr. Donijo, ki ga bo skupaj z mano vodil kolega Bahtjar Raljav, kodirektor Mednarodnega inštituta IFIMES. Ob tej priložnosti se rad zahvalil za pomoč pri organizaciji dogodka Centru Evropa in Uradu vlade za komuniciranje, ki sta sodelovala pri organizaciji današnjega dogodka. Prepuščam besedo kolegi Aljafu, da vas tudi še ne govori v angleščini.
Ladies and gentlemen, dear friends, I would like to welcome you on the behalf of the International Institute of the Middle East and Balkan Studies, IFIMES. It's a great honor for us to introduce to you the President of the Council of our Institute, Professor Dr. Robert Donia. Dr. Donia is Associate Professor at the University of Michigan, and his stay in Slovenia is a part of his European tour. He is also a research associated at the Center of Russian and East European Studies at the University of Michigan and visiting professor at the University of California in San Diego. He is the author of numerous books, articles and reviews in scientific magazines dealing with the former Yugoslavia. He is the advisor of the Hague War Crime Tribunal. The topic of his today's lecture is Does Justice Matter? The historical imperative of assessing the ICT-why. As we all know, the Balkan region has become known as the home of endemic violence. National and religious extremism have often led to widespread violence and breaches of human rights, but always in ways that serve the interest of major power holders. In his lecture, Dr. Donia explores the interest of those power holders, why they are often successful in gaining support for the undertaking, and the ways in which the incentive for violence can be reduced through international policies. Before I give the floor to Dr. Donia, I would like to thank my colleague Ziad Bečirović. He is co-director of our institute, who will assist me during this lecture, and of course I would like to thank Center of Europe and Government Office of Communication for helping us organizing this event. Dr. Donia, please, you have the floor.
Co-introductions. It's a privilege to be with you in Ljubljana, a town that I first got to know in 1965. Time probably exceeds the lifespan of many of you here, except for a couple of you, and including my longtime and good friend Mitya Mershol, who's with us today. So my friendship has been not only with Ljubljana, but with a number of key people who've been important to me for a long time. I would like today to speak about the ICTY, the International Criminal Tribunal for the former Yugoslavia, or as it is formally and legally named, the International Tribunal for the Prosecution of Persons Responsible for Serious Violations of International Humanitarian Law committed in the territory of the former Yugoslavia since 1991. You can now understand why they use the abbreviation ICTY for this tribunal. What I would like to do today is to argue for a thorough assessment of the work of the tribunal at this particular time as it prepares to close its doors, complete the last of its trials, and become something that will probably be little more than an archive attesting to its various activities. The tribunal was formed in May of 1993, and thus is some 16 years old. It was founded by United Nations Security Council resolution, and go back if I can, housed in this building in The Hague, which was built in the 1920s. It's an insurance building. It was built to house an insurance company. Inside, you still have the musty smell of hundreds of thousands of insurance policies that were once laying around, and some of the archaic characteristics of this building, which has housed the tribunal. In the building are, just immediately facing you, if you can see the picture, 3 courtrooms, which have been the scene of all trials at the tribunal starting in 1995, which means that a lot of activity has taken place in relatively few courtrooms, and actually put quite a bit of pressure on the tribunal in the use of those courtrooms. Why do I believe that we need to make a thorough assessment of the tribunal at this time? First of all, the ICTY represents the first major application of international humanitarian law since about 1950. Of course, the post-World War II era led to the Nuremberg trials, which constituted a major exercise of international humanitarian law. The second reason for my suggesting a thorough assessment now is that the ICTY has become a model for 5 other ad hoc tribunals that are currently at work, and the International Criminal Court established in 2002. Just how much of a model has it been? Well, I'll show you the 2 courtrooms, and you'll see that they're laid out almost exactly the same. Panel of judges at the front, the defense on, as you face the judges, the left side of the room, the prosecution on the right-hand side, and a small table where witnesses sit directly in front of the officers of the registry. This is not all. The ICC is only a few blocks away from the ICTY. It has in fact hired many people who worked previously in the ICTY, and even those who do not necessarily have a background at the ICTY shop in the same grocery stores, walk the same streets as people who have been at the ICTY for many years. So the influence of the ICTY on the ICC is profound. And I think it's particularly important to look critically at what the ICTY has done so that the successor court, the International Criminal Court, which has much broader, virtually universal jurisdiction, can learn from the lessons of the ICTY. And furthermore, it seems to me the court should be assessed not by its fiercest critics, of whom there have been many over the last 16 years, but on its own terms, according to the objectives set for it in the United Nations Security Council resolution and the statute of the tribunal. It should be assessed, in other words, by its friends, as well as it has already been by its enemies, with the object of improving the subsequent exercise of international jurisprudence. The ICTY, of course, is not the International Court of Justice, the ICJ, which is the official organ of justice for the United Nations. The ICJ was established along with the UN and the UN Charter of 1945. It settles disputes between states only. Individuals cannot bring cases before it, nor does it judge individuals in any way. It has 15 judges, a rather large number, and something of a cacophony at times, serving very long terms, 9 years each. To make it easy to confuse this with the ICTY, it is also just a few blocks from the ICTY in The Hague, in the famous Peace Palace building, which has also hosted many peace talks over the decades. The ICTY is also not the International Military Tribunal or the Nuremberg Tribunal, which is an important precedent in terms of international jurisprudence, but differs from the ICTY in a couple of very important ways. I'll use the term victor's justice, intending not to mean that the Nuremberg Tribunal was simply an exercise in the will of the winners, but rather that the defenders or the losers in the war were in fact leaders of a totally defeated aggressor state, which changed the dynamic of the trials in important ways. For one thing, large intact document collections captured from German sources, German archives, were immediately available in full to the prosecutors, something which has not been the case at the ICTY. The Nuremberg trials used an accumulated body of the laws of war, which of course go back, in fact, many centuries, but it took specific form in the 19th century. But it proceeded prior to the adoption of the Genocide Convention in 1948. So it used the laws of war pretty much exclusively as the basis for its judgments, and did not have at its disposal many of the human rights conventions that have since been adopted by the United Nations. Well, what are the key principles that the ICTY has stood for, has sought to implement in its work? First of all, and I take this directly from the website, the newly restructured website of the ICTY, its business is bringing war criminals to justice. That's its primary mission. It's very clear in the United Nations Security Council resolution. And to date, something over 160 people have been indicted, tried, acquitted, or judged, and some of those trials are still in progress. So not a large number of persons, but obviously including some of the most important leaders of the war, including one head of state, of course, Slobodan Milosevic. The second principle that you can learn from the website is bringing justice to victims. And this is, in fact, a very secondary objective as identified in the United Nations Security Council resolution. But many critics of the tribunal, and in fact many of its friends have seen this principle of reconciliation, or bringing reconciliation to victims through justice, as critical to the tribunal's success. And I'll have more to say about that in a minute. But it is clearly a secondary in the eyes of the tribunal itself, a secondary but very important objective. Third has been to hold to the principle of individual responsibility for war crimes and to reject completely collective guilt of any country, of any nation, or any ethnic group. And you will find this principle elucidated in every case before the tribunal repeatedly by judges on the panel, and certainly in the public statements of the prosecutor and the judges. Respect for the rights of the accused has been a key principle that the ICTY has sought to honor. And again, judges have made that very clear in every case that has been before the tribunal, and have exercised that respect, not only in terms of their legal rights before the tribunal, some of which have been contested, but also in terms of simple courtesy in the courtroom. If you ever go to see a particular trial in action, you will see that the defendant or the accused and the defense lawyers are treated with genuine respect by the court itself and even by the prosecution attorneys. Finally has been the independence of the prosecutor and judges. And for the judges, I think this independence has been not really been at issue. For the prosecutor, I think it's been very difficult for the prosecutor to be independent of political pressures, and one can certainly identify times when the prosecutor seems to have, in fact, at least been sensitive to political pressures on the office. Well, what are the characteristics then of the ICTY as we see it today? And I'll just briefly talk about the physical arrangements. There are 3 judges for each case. There is no jury. There are appeals panels, and virtually every case is appealed either by the prosecution or the defense to an appeals panel of 5 judges of senior stature. You may have noticed in the last few days that the defense appealed a case in which the defendant actually received 3 times the sentence from the defense or from the appeals chamber. There is a story that goes around the tribunal of the lawyer who represented such a defendant, came to see him and said, "I have good news and bad news." And the defendant says, "Well, I've gotten 3 times the sentence that I originally had. That's got to be the bad news. What's the good news?" And the attorney says, "No more appeals." So the appeals panel in some cases has virtually retried the case, even called witnesses anew, and brought in additional information, which, as I'll indicate shortly, I think has not been a helpful practice at the tribunal. The courtroom, as I indicated earlier, is a pretty sizable place, at least courtroom 1 is. There are as many as 8 defendants that will be on trial together at times. Each of those defendants is entitled to have 2 lawyers present. So it gets to be quite a crowd on the defense side of the House. There are, of course, the 3 judges, the representatives of the registry, and anywhere from 1 to 5 prosecution attorneys. So the courtroom is elevated, and underneath is a sea of wiring. It is simply impossible to operate in the courtroom without the benefit of a microphone. Everything has to go through translators or interpreters who simultaneously interpret into 2 other languages. The 3 operative languages are Bosnian, Croatian, Serbian, French, and English. So the courtroom is further populated by a fair number of linguistic experts. There is a small witness table facing the judges. There are also 2 computer screens at the witness table. The easiest thing in the world is to start following the text on one of those computer screens and completely losing what you were about to say. So that can be a source of real confusion. But the witness table does put the witness close to the judges and close to both the defense and the prosecution. It's a little bit cramped, but I think serves that function well. And this general physical layout is one which I think is going to be made permanent in the International Criminal Court for the foreseeable future anyway. The trials at the ICTY have been long and complex. The judgments are very lengthy. Judgments can run easily 500 pages. Some of them have run considerably more. And that is simply the judgment of the trial chamber. The appeals chamber judgments are normally shorter, but also add to the sheer bulk of information. Many of the judgments fall into 2 categories. They, first of all, judge the crimes that were alleged to have been committed, and then speak of the role of the accused in those crimes. So in that sense, the chamber functions to document what occurred, as well as the liability or responsibility of the accused for those crimes, and which I think has been a very helpful feature of the system. The huge problem, however, lies that the judgments so far have been rendered only in English, so that they're not accessible in the local language. There are summaries that are available, but to have those only in English is a major problem. Why are they so complicated? Why are these trials so complicated? Well, first of all, the ICTY arose as something of a surprise. It had an inauspicious beginning. United Nations Security Council 827 passed in May of 1993. For those of you who may have been following it, realize that this was perhaps the darkest hour of the war. It was just after the Bosnian Serb Assembly had rejected the Vance-Owen peace plan. They had called a plebiscite, and the Serb population of Republika Srpska had likewise rejected the plan. And the international community was in disarray in terms of how to deal going forward with the war in Bosnia. Additionally, the war between Croats and Bosniaks had begun effectively on April 15th, 1993. So the situation in Bosnia was further complicated by that ongoing and very, very bitter war. The response of the United Nations Security Council in creating the ICTY was therefore something of an act of desperation. They really did not know exactly whether this would succeed, and had relatively few firm ideas about how it should go forward. Given that inauspicious beginning, to be here where we are 16 years later, I think is rather remarkable, and a tribute to both the determination and ingenuity of many of the people who led the process. Second, the perpetrators of crimes, war crimes, in the region included many crafty criminals, and they committed complex crimes. In looking over the documentation of that the ICTY holds on these matters, I've come to the conclusion that key players were engaged from the very beginning in a cover-up of what they did, using a vocabulary and a discourse to describe their actions which deliberately tried to obscure the criminal nature of their deeds, and specifically entailed building a defense from the first day that they began developing plans. That means that the investigators of these crimes, and the judges as well, are faced with the business of ferreting out what really happened from the rhetoric of the people who were its principal perpetrators. And I show as Milosevic and Karadzic as two such practitioners, but they're not the only one, and certainly not all of those who engaged in this kind of murky effort to muddy the waters were Serbs. The situation is further complicated by the fact that there was no clear winner to the wars of Yugoslav succession. The court struggled from the very beginning with not only getting the belligerent parties to turn over accused, but also to provide documentation that the tribunal requested on the activities of the accused. The prosecutors have further chosen to charge a broad spectrum of crimes. Unlike the Saddam Hussein trial, which I personally think was a kind of a kangaroo court, and not in any way meeting the standards of international justice. But in the Saddam Hussein trial, essentially he was convicted of genocide for one episode that took place in 1989, in which I think 143 people were killed. And it has been the judgment of the prosecutors at The Hague to charge all major crime scenes, which of course would include dozens of situations, each of which requires its own set of witnesses, its own documents, its own explanation and linkage to the accused. So the trials have gotten long and complex in substantial measure because of this judgment of the prosecutors to charge a broad spectrum of crimes. The perpetrators have often been protected by the belligerent states they once governed. Some of them remain national heroes in places where they once operated. And consequently, this massive documentation, it is millions of documents, have been acquired over time, incrementally, with vital information selectively withheld by the belligerent states. That is one of the reasons that the appeals chambers have had to consider new evidence 5, 6, 7 years after the trial began, because that evidence only became available with time. And finally, although I don't believe it has had a major impact, the security services of various countries have actively undermined the ICTY. The government of Croatia under Tudjman had an active operation to recruit agents within the ICTY and to essentially provide information directly to the accused and to assist assist indictees in evading capture by S4 forces. Now, the ICTY has had some major achievements, in my view, and with this I'm going to go ahead and, since no one else seems to be stepping forward, offer a critique of my own of the ICTY, in the hopes at least of creating some categories within which we might view the achievements or failures of the ICTY. First of all, you have to say, I think, that the ICTY has accomplished its core mission of identifying, indicting, capturing, and trying most of those who are actually indicted by the tribunal. Most have been convicted. Some have been acquitted. Many have received light sentences. There are, of course, ongoing trials and 2 accused, Mladic and Hadjic, who are still at large. With persistence and determination and a great deal of support from the international community, the ICTY has either won support, grudging, partial, or full cooperation from states in the region. It bears stating that the government of Bosnia-Herzegovina was a full cooperator at the beginning and provided essentially the corpus of documentation, which still is the basis for many of the prosecutions. That cooperation became less than complete in the course of time, but still the government of Bosnia-Herzegovina, now the Federation of Bosnia-Herzegovina, has in fact been the leader in cooperation with the ICTY. The ICTY has aided in the development of transitional justice in the region. In my view, this is its most important, is likely to be its most important lasting success. And by transitional justice, I mean the justice in belligerent states, former belligerent states, intended to try their own war criminals or those responsible for crimes committed on their territory. In addition, the ICTY has developed international humanitarian law in 3 key areas, in fact many areas, but I would identify as the most important those in identifying the definition of international armed conflict, the use of the concept of joint criminal enterprise, which preserves the notion of individual responsibility but allows for a conspiracy amongst a limited number of participants in planning and executing a crime. And finally, in the definition of genocide and what constitutes genocide, particularly in the Krstić case and other cases involved with Srebrenica and also the Stakic case in Prijedor. Here are the categories I would propose to look at, and I'll briefly go through each of them and offer a very personal assessment in each of these areas. Victim justice and reconciliation, that second principle that the ICTY itself espouses, the secondary purpose, in my view, has completely failed. I don't see very few, if any, victims who feel that justice has been done, feel better because justice has been done, or that justice has been sufficiently done. And in fact, victim groups on all sides are extremely unhappy whenever a judgment comes down, and many individuals do too. Now, this is an important conclusion, because I believe the tribunal has spent a lot of time and made a major commitment to try to produce reconciliation through justice. It simply appears that the notion of victim justice is an unrealizable ideal, at least for an international tribunal. And I would hope that the successor court, the ICC, does not task itself with having to be measured on metrics of achieving reconciliation or victim satisfaction. Put it bluntly, victims' justice is an unrealizable ideal, not something really that human institutions are able to deliver to the true victims and the survivors of these horrible crimes. The court has never devoted substantial means to achieving significant reconciliation. It has certainly tried in a couple of cases to achieve that by getting confessions and so on. But to my way of thinking, this part of the ICTY's mission has failed and should not be a part of future mandates for international justice. Transitional justice, on the other hand, may be a substantial and lasting consequence of the ICTY's activities. It has contributed as a model and counselor to local war crimes chambers in former belligerent states. I was in Bosnia last week and met the chief prosecutor of the cantonal court in Tuzla, who had just had a meeting with several of the prosecutors from the ICTY. And she was absolutely enthused about the support that they were giving her and the instruction, really, that they were giving her on how to structure war crimes trials and how to get this done. In terms of the Bosnian state court, the ICTY has had a direct and significant impact in shaping that court and in sort of guiding the process. It has not, however, taken on a role of monitor, and I think that that would be a function that could be added to the mandate of future of any successor court, the ICC I refer to mentor development of local justice systems and perhaps designate a deputy registrar to facilitate that advisory service. It can't be done simply by prosecutors, can't be done simply by judges. It certainly cannot be done solely by the public relations outreach function of the tribunal. But a coordinated effort amongst all those groups, I think, could have a substantial effect, certainly has had some real successes in the region. And I would like to see successor courts be willing to monitor transitional justice proceedings in belligerent states and issue periodic reports on those activities to the UN. We have a situation in Southeast Europe today in which there's something of a war going on among the judicial systems for the right to try war criminals. This is most unfortunate, and I think could have been avoided had the ICTY firmly assigned particular cases to particular jurisdictions, so that this jurisdiction war would not really disrupt the ongoing efforts to enlarge the EU in the region. Transparency. I have a real concern about where the ICTY is headed now in terms of transparency, but would note that generally speaking, the ICTY has operated with transparency, but access is very problematical, by which I mean everything happens in The Hague. It happens 1,000 miles from Sarajevo and Zagreb. It's very difficult for a person who is not on site and furthermore very familiar with the institution to figure out what's going on. The ICTY badly mismanaged the transition from paper to the digital age. Just in the last 2 weeks, finally, in this restructured web page, the tribunal has put online the public portion of the judicial registry, which includes many of the documents. The problem is, unless you already know where to go to look for them, you can't find them. The search engines are poor, and the process is certainly better than nothing at all, but far from highly effective. The registrar has a mixed history of, at times, favoring transparency and at times protecting documents that really did not need to be protected from public inspection. I would like to see the registrar shift the burden of proof to those who want to restrict access to a document and become essentially an agent of transparency as well as simply a custodian of documents. I'd like to see some proceedings of the court held in the region of conflict as conditions permit. I think that would considerably expand the sense of the tribunal being in touch with the local region and local people being able to understand what's going on in the court. Panels of judges and the prosecutors should include regional participants, either as observers or as full participants, as it becomes feasible to do so. This is one of the real problems at the tribunal today, in that so much goes on in which the prosecutors, the key prosecutors and judges do not have the linguistic ability, the language ability, or any real sense of what's going on in the region. They're very abstracted from what's going on in the ground, and I think that could be easily remedied. In terms of evidence, and I speak now here mainly of documentary evidence, we've been through a whole host of different systems, from the paper to the electronic age. And only now is the tribunal thinking about its conversion from a base of documents to prosecute crimes to an archive. In fact, from the very first day, this collection of documents was an archive. And a professional archivist reporting to the registrar could establish a dynamic living archive open to all users as appropriate. Archivists all the time engage in protection of documents that are not public for one reason or another. They are the ones with the skills and the systems to make sure that those safeguards are in place. And I think treating the holdings of the tribunal as an archive from day one would be an extremely beneficial, would have a lot of long-term benefits and make the documents more accessible to everybody. I'd like to see conditions for secrecy have a specified time limit, no longer than the laws of the donating country, sovereign state, or the UN itself, and make all documents, working papers, and judgments digital and searchable. Now, many of them, in fact most of them, are today, but only after a great struggle to get there. Expertise, which is a bit of a kind of technical aspect of this. There is a sizable research team within the Office of the Prosecutor in The Hague called the Leadership Research Team. Virtually everyone on that team speaks the local language. They have become extremely knowledgeable over the years about the documentation, about the events in the course of the war. Unfortunately, it is in the Office of the Prosecutor, and that creates an inherent inequality of arms. The defense struggles to maintain knowledge of the document base and doesn't have the benefit of some of these experts who know so much. I would propose that the research team be placed under the registrar and made available to all parties. This also would help the judges. Anytime a new judge comes to the tribunal, they face a major task simply in mastering some of the detail of the war, the fundamental facts that are sort of become second nature to everyone who's there for a few years. And I would think that a research team accessible to the judges could put together an orientation program for new judges that would meet some of those needs. A research team could include short-term experts with area expertise. In the case of the ICC, that will mean various parts of the world, but also full-time employees with disciplinary expertise. And I would argue for a research team that is interdisciplinary. Most of the people on the research team now, bless their souls, are historians, which means, of course, they're very good people. But I would propose that linguists in particular have a critical role to play in explicating the events and the background of the events that are discussed in the trials. But anthropologists, political scientists, sociologists, I believe that if you actually asked the participants in the leadership research team this question, they would agree that there needs to be a much broader interdisciplinary approach, essentially to broaden the approach beyond lawyers and historians. I hesitate to group those people together, but okay, time. Time is a really critical issue because cases, I think the record now is 7 years for the longest case, from first witness to appeals judgment. That was the case of Tihomir Blaškić, which began in 1997, ended in 2004. The trial chamber sentenced him to 45 years. The appeals chamber reduced that to time served in 2004. So there was a great deal of change that went on in the course of that trial. Expediting trials would mean limiting the crime base. It would mean that only so many actual crimes, perhaps those with the closest link to the accused or the most representative, could be presented to the court. Now, one of the reasons that the prosecutors have chosen to prosecute a wide range of crimes is this very consideration of victim justice. And if you take that out of the equation, I think it would at least argue for fewer crime scenes being made part of a particular complex prosecution and might lead to substantial shortening of the procedures. Another problem that I think any outsider would look at is the propensity of the panels to retry individual crime scenes in multiple cases. So in Prijedor municipality, for example, there have been about 7 or 8 different cases that have dealt with Prijedor in one way or another. The crime base, the facts are essentially the same. Some of the witnesses get called repeatedly. The documents get re-entered into case after case. And so developing a system in which a panel's admission and conclusions could be considered in another trial, I think would be an important time saver. There's a great deal of irrelevant information. One could argue a majority of the time is spent on irrelevant information. And to have judges determine relevance in the course of the testimony, rather than hearing all the evidence and then determining its relevance in the judgment, could, I think, be another factor to expedite proceedings. The absence of key documents has been a major source of slowing down proceedings. And I think that substantial support from international bodies and sovereign states for the tribunal's efforts would considerably contribute to those considerations. I would propose that only trial chambers consider additional evidence, that essentially a case be returned to a trial chamber for additional evidence rather than retrial in the appeals chamber. One of the common events is that indictments are issued well before the case is ready to go to trial. I think this happened in the indictment of al-Bashir, the president of Sudan. He was indicted in July of 2008, and when the arrest warrant was issued just a few months ago, the court actually refused to include the charge of genocide because the information, the documentation was insufficient in their view, to warrant that charge as a part of the indictment. Let me conclude and then invite your questions, comments, and disagreements and disputes. I believe the ICTY has accomplished its core mission, trying, convicting, and acquitting people. Certainly not all the guilty. There are tens of thousands of people who have been involved in war crimes who are still in Bosnia, Croatia, Serbia, and not all of them, of course, have been anywhere near the reach of the tribunal. Significantly, I think that the proceedings have not contributed to reconciliation. I think it would be constructive and useful to recognize this and remove it from the agenda, from the burden of future tribunals. The most significant secondary achievement, on the other hand, has been the contribution to transitional justice, which is a very major contribution and a lasting one. And I think in general the tribunal's ability to do this should be leveraged more through various mechanisms. And finally, the related issues of transparency and access, I think, require major adjustments in the practices of successor courts and in the subsequent treatment of the ICTY archives. There's a whole raft of issues there that I have not had time to go into, but would argue that the court is in the process of erring on the side of seclusion and closing documents. Those are my conclusions. May I invite your questions?
Thank you, Dr. Donia, and would like to ask Mr. Bahtiyarallah to start with the discussion.
Any question? You can sit down. Yeah. Yes. If you have any question, you can ask for me. Yes.
How are things looking at the moment? Because I know that the ICTY was due to close next year, and I know also that the European Parliament recently adopted a resolution saying that the ICTY should stay open in the case that Mladic and Hadjic will be captured and delivered to the ICTY. So how do things actually stand? What is the actual state of play? Will the ICTY continue to work in the case that they are captured, either one of them or both of them? Will it reopen in the case that in 2011 or 2013 Mladic is found?
Yes, well, I think you've just summarized the state of things. Those are all open questions at the moment. The UN bodies concerned, specifically the Security Council, has consistently resisted ideas to extend the term and then ended up doing it. And my best guess would be that it will do something like that again, given the European Parliament's position and the general support for this amongst some of the major contributors to the tribunal. There is a commission that has been tasked with, it's a UN commission that has been tasked with determining the fate of the archive. And I think that when you start to look at the question of the archive, you quickly come across the related issues of cases that are, well, the two at large accused, and also cases of relatively high-level accused persons in the transitional justice systems of the belligerent states, former belligerent states. So it doesn't seem to me very plausible that the UN will simply close this down. There has to be some sort of successor organization at the very least to maintain the archive, and it would be relatively easy using that as a core to provide for the continuation, perhaps at a skeletal in a skeletal structure, a very dramatically reduced size of the tribunal. But that's nothing but a personal opinion.
Mr. Mitjan Mershol.
Well, in introduction to your speech, you said, to your excellent speech, you said that prosecutors especially were somehow exposed to some political pressure. And could you be more specific about this?
Well, certainly the chief prosecutor came under pressure from the U.S. Not to pursue investigations of the consequences of the NATO bombing in 1999. The prosecutor, actually, if you just go to the recently published book of Carla Del Ponte, you see that she was constantly under political pressure from every major player, from the states in the region to the major powers, including the U.S., which was an enthusiastic early advocate of the tribunal, and has maintained some of that support, but particularly under the Bush administration, began to have some more skeptical approach. So most of that pressure, frankly, has come at the level of the chief prosecutor. And I shouldn't say that individual prosecutors of individual cases have been constantly exposed to political pressure. They certainly are aware of the views of the various players on their activities. But most of that pressure has come directly to the chief prosecutor.
Dr. Milan.
Yes, thank you. Well, since half of the row has asked the question, I will also have one. Referring to the transparency issue, I would like to ask you, Professor Donia, what is your impression, let's say, speaking with citizens in Bosnia, with, let's say, ordinary people who are not part of the establishment? Does the ICTY have a reputation, or can you see among the people the importance of all this, what has been achieved within the legal framework? I mean, let's say, or does public opinion registers and appreciates the notion of the ICTY as such, for values, for justice, for, let's say, for some basic justice among people?
No. I think the public in Bosnia and Herzegovina, all publics in Bosnia and Herzegovina, are riveted on an actual judgment when it comes down. But they don't care what the judgment says, they only care about the sentence. Now, in a few cases, they do care, they very much care whether genocide has been determined. That would be the one thing that I think all publics are concerned with. But the sense of justice that any Bosnian is looking for is not the abstract sense of the progress in international law that a particular panel may have made, but rather the sense of, if you will, retaliation or punishment for the perpetrators as measured in the years of the sentence. So everybody is disappointed all the time in those rulings. It's just no exception to that particular situation. Now, there's another side of this that I think perhaps there is some awareness of, and that is that the ICTY has aggressively pursued documents within Bosnia, aided by document raids conducted by S4 and exhumations initially done under S4 protection, and now proceeding throughout the country, or in several places in the country, without the assistance of U4. And I think that the publics of Bosnia are in fact aware that the pursuit of truth is going on, in large measure thanks to the tribunal. That this would not be going on at this level were the tribunal, had the tribunal never been formed.
I would very much agree with your conclusion about the victims' justice being an unrealizable goal. And I completely agree that other tribunals, or in particular the ICC, should go that way. But I'm sorry to say that the way things look now, it seems the ICC is going the other way, sort of giving victims more powers, or basically giving them a status of participants. And it seems that other tribunals are heading that way as well. So why aren't we learning, for example, from ICTY in this respect? Or in light of your idea, even if you look at the special tribunal for the Lebanon, or how maybe the progress will go on in that way. And a question I would have is basically whether it would have been better, for example, for the ICTY perhaps to be situated in the region instead of The Hague. Would that help the outreach, or basically the victims feeling more close to it, or it wouldn't have made a difference in any way?
Well, it might have, and I think there are a number of reasons why it was not. Number one,
impartiality.
Well, there's the impartiality issue, to be sure. There's an argument about sheer space and facilities, and getting a distinguished panel of international judges to live in, let's say, Bihać for an extended period of time, as opposed to The Hague, would have been very, very difficult to do. And certainly, for example, someplace like Budapest or even Ljubljana would have been a very secure environment in which this might have been, might have taken place. On the other hand, the problems of conducting the size and scope of trials requires immense support from the local community. You need a lot of places for people to live, talking about over 1,000 employees. You need, a place where they can go to restaurants to eat, and all these sort of secondary support issues. My thought was, as a compromise, to have it housed at a permanent location, of which The Hague has many very positive features, but to try to hold limited sessions in the region as soon as possible. And there have been some panels that have toured crime scenes in the region. And I always, when I ask people about this, I find that that's a very enriching process. It's very difficult, it seems to me, for a judge or even a prosecutor to get a sense of crimes without having a physical sense of the layout. I mean, in some cases it's stunning. If you walk the hills above Sarajevo and you see the incredible exposure, vulnerability of the city to attack by artillery, and the detail in which you can see individual human beings walking in the streets below, there just can't be very many places in the world where that's true. So I would be in favor, myself, of having as much happening in the region as possible and as close to the actual crime scenes as possible. But I think there are some real constraints, and some very legitimate reasons to go slowly in making that possible.
Yes, please.
Well, Dr. Donia, thank you very much. I think you have done very excellent job and assessment for the tribunal through phases which went, and what you said at the end about reconciliation and about the justice of victims, that is true. But knowing the mechanism of United Nations, how it works, and how it was in 19th and how it's the balance of power now and situation, I'm afraid that it might be the job of the tribunal unfinished. And I think that's very bad if it's the timing, as you said, not to bring before justice main actors of the war like Mladic and Karadzic and others, which I mean still are. Karadzic is in, but let's hope they will finish before because forces of the opposing the tribunal, I mean, can misuse the United Nations, and I think it is going to have not a positive impact, although I'm not going to take time here, neither to others, neither to you, to say how it was reflected to ordinary people, how, let's say, in Slovenia, how it in Bosnia, how in Serbia, how is in Kosovo, which is very much as well. Kosovo is one of the components, one of the important components at the end of this tribunal. And reconciliation is nowhere, neither between Serbs or Bosniaks, neither between Albanians and Serbs. So this, I think, is going to have a negative impact in area if forces who wants to finish the work of the tribunal can succeed to. This is my opinion about it.
Yes, I agree with you. It would be most unfortunate if that takes place. That is, if the tribunal just simply, a line is drawn in time and it all stops. I still view it as unlikely that it will happen that way, but certainly the forces are there to prevent its really to bringing its mission to a conclusion, if you want to put it that way. I find it hard to be optimistic that the UN will do what I am proposing here, which is to take a hard look at this huge investment and try to learn something from it. And there are a couple of reasons why I'm pessimistic about that. Number one, the ICC is already off on a flight path that is, in some respects, quite alarming. I think they've been drawn to the one situation in which many people believe that genocide occurred. I think this is very dangerous. I'm very concerned about the tendency to pursue genocide cases in a way that diminishes the significance of all other war crimes. And also we're dealing with some some persons with some very large egos who are at the head of these institutions and trying to make careers and reputations for themselves in short order. That's always a problem in the UN. It's a problem in the U.S. too, for that matter, and the European Union as well. But the speed with which this is all proceeding is, let's say, and the non-reflective character of the proceedings is what really kind of is alarming. And I think it's going to be very difficult to try to say, let's take a look backward and see what we can learn. Try to learn from other people's mistakes rather than our own.
Next question. Na koncu da se še enkrat zahvalimo profesoru doktoru Robertu Doni na izjemnem predavanju, na odlični razpravi in da še napovem naslednje dogodke. Jutri ob 11. uri profesor Donija in Jelko Kacin, poslanec Evropskega parlamenta in poročevalec Evropskega parlamenta za Srbijo, boste imela skupno tiskovno konferenco. To je ob 11. uri, v petek ob 11.30 gostimo na Inštitutu Evropskega komisarja za znanost in raziskave dr. Janeza Potočnika, ki bo predaval na temo znanosti in razvoja Evropske unije.
I hope that you enjoyed this lecture and discussion as much as I did. I would like to thank Dr. Donia for this contribution to better understanding the situation in the Balkan region, and thank you all for coming and for taking part in this discussion. Thank you.